Thanks, guys. Hey, RG Nation, Brian Durham here, managing broker with Jackie, our on-staff attorney, and today we're going to talk about putting some teeth in your contracts and the defaults that we're seeing in this market. All right, Jackie, so we're seeing a lot of defaults in Minnesota, Wisconsin. Year over year is up tremendously from what I'm noticing just anecdotally and talking to agents. Florida, it's hard to say because we're so new there, but I know our Florida agents are going to be dealing with this too. What are you finding is the biggest issue right now?
What we're seeing over and over again is a refusal to perform under the contract. It gets close to closing and we have one party or the other that's simply digging their heels in and doesn't want to move forward. But in Minnesota, Wisconsin, Florida, everywhere that Realty Group is at, the law is really clear. Every state incorporates a covenant into all their contracts. It's known as the implied covenant of good faith and fair dealing. Basically, what that means is that parties can't just, in bad faith, refuse to perform under a contract. Anytime a party doesn't fulfill a promise they made under the contract, by the time performance is due, they're in breach. And refusing to close when there aren't any outstanding contingencies is a breach.
All right, so it's 12:01 on the 8th day of my 7-day inspection contingency. We couldn't come to an agreement with the sellers. Now my buyer wants to back out because they refused to fix the things that they wanted. Now what does that mean?
They don't have any basis to cancel the contract based on those repairs they want that they found in the inspection. The contingency that existed that gave them an out based on those repairs, if they couldn't negotiate something with the seller, expired. So if they're at this point now refusing to close because they can't get those items that they want, they're in breach of the contract. They can't refuse to do that based on that.
So another one that I know we're seeing a ton of on the broker services line is earnest money and issues with not being delivered in the 72 hours. What's the remedy for that? Is there a remedy? Does that cancel the contract now? If let's say the seller got another offer, but now it's, they want to move forward with that new one or they want to go back on the market. What's the issue there?
So failure to deposit earnest money on time is what's known as a curable default. It's a default that doesn't in and of itself cancel the contract. There's still a breach, but it's one that can be fixed.
With pretty much everything, it goes back to it has to be unilateral, right? Like buyer and seller have to agree to it unless there is a clause in the purchase agreement that says one can act unilaterally, which really there's very few of those.
There's fewer provisions in the purchase agreement, you're right, that state if such and such happens, this purchase agreement is canceled and buyer and seller shall sign a cancellation. That's an uncurable default. That's a default that by itself cancels the purchase agreement, which is different from a curable default. And failure to close on the scheduled closing date, refusal to close on that date, is also a curable default. So when you refuse to close on your scheduled closing date, your contract isn't voided. What you're left with is a messy contractual situation, but you still have a contractual situation.
So buyer can still make the seller sell, seller can still make the buyer perform. If they both refuse, now what? Now what's the next steps, I guess?
Once one of the parties has breached the contract, the other party has the option to seek remedies. What remedies might be available to them is going to depend on exactly what's been breached, exactly what the parties want to do, exactly what makes sense in the situation. But the non-defaulting party will have the option to look into that.
And this is usually where, from the broker services perspective, we're saying you should probably have your client contact an attorney on their own.
That's right. Anytime you're dealing with a buyer or a seller, your client, the other party to the transaction that's refusing to do something they're supposed to do in the transaction, that is hindering the transaction in any way, shape, or form, you should refer your client, whether they're the party that's refusing to do something or on the other side, to talk with legal counsel about what that means for their transaction. And I would also encourage agents to reach out to broker services at that time too. I don't need to tell you how much easier to proactively address a potentially dicey situation versus, reactively respond to something that's already unwound a little bit.
Yeah, I always tell them it's much easier to stop the bell from ringing than to unring the bell after the fact. And I know it helps us out a lot when agents reach out as things start to go sideways instead of after the fact and they're trying to scramble to fix things at that point. It does help us a lot. So here's another fun one, Jackie, that just recently happened. Day before closing, we're representing the seller, and on the broker services line, we get a phone call from someone who is claiming to be the seller's wife. They got married in Vegas, and she doesn't want the transaction to move forward. She lives in another state. Buyers are really unhappy because they're expecting to close the next day and move into the house. So that's definitely a cloud on title. What's the contract have to say around that?
Purchase agreement standard language states that the seller gets 30 days to resolve any title issues that affect marketability post-closing.
Okay, so if the buyer says, we don't know how long this is going to take, we want to cancel, and the seller says, no, we've got a contract, I don't want to cancel, and I'm not going to sign a cancellation. We wanted to extend, and buyers didn't want to extend. Now what happens?
The contract language is really clear that the seller gets 30 more days, shouldn't say post-closing, to close, to resolve the title issues so that the deal can close. So 30 days following the scheduled closing date. You can kick it out 30 days, and that's right in there. So buyers can't say no.
Perfect. Thanks for coming in, Jackie. We appreciate your time. RG Nation, thanks for tuning in to CEO Connect and our Out and About segment with BS. Remember, we are always here to help you guys, 8 to 8 Monday through Friday and 10 to 6 on the weekends. You can either call, email, or text, and somebody will take care of you as soon as possible, and we'll get those questions answered for you.